Hi, my name is Stewart, and I'm an attorney in Northern California. My business focuses on business law, estate planning, and intellectual property matters. Now, under business law, I do a lot of contract work, and part of doing contract work is setting up relationships between businesses and the people that work for them. And one of these important relationships is the relationship your business will have with an independent contractor. And a lot of businesses like an independent contractor relationship with people that'll work with them because they get to avoid a lot of the problems that come along with having employees. At-will employment doctrine is somewhat eroded in the state of California, and also there's a lot of taxes that are required to be paid if you do have employees. And that's why it can be a very attractive option to have an independent contractor. You don't have to pay as many taxes with them, and you can also terminate them, frankly, a lot easier than you can an employee. The difficulty, though, with setting up an independent contractor relationship is that you truly do have to structure it in such a way that it couldn't be considered an employment relationship. One of the most important factors with that is the amount of control that you as the employer, or rather as the business owner, exert over that person. If they can basically perform the project or task they've given them at their own discretion, at their own location, when they want and how they want, that smells more like an independent contractor than it does an employee. If, however, you're pretty much micromanaging how they work and what hours they work, then they're starting to look more like an employee. So it's important to not only structure the agreement in a way that makes them independent contractors, but to follow through and make sure that the relationship itself is that way. The consequences for not doing so is you can get in a lot of trouble with the tax authorities and have to pay back taxes that you should have paid for employment, and you don't want to do that. The other very important thing to have with an independent contractor relationship, especially in any kind of tech or artistic field, is making sure that the intellectual property that they're creating for you becomes your intellectual property. And the reason I say this is that if you have an employee, by way of contrast, and they create a piece of software for you, or they create an artistic work for you, well, the default law says is that if they've created that pursuant to the employment relationship and within the scope of their work, it becomes your intellectual property as the business owner. That's exactly the opposite with an independent contractor. If they create something in the scope of that relationship, that is still their intellectual property. And not a lot of people realize that. And that's why it is very important in your independent contractor agreements to have sufficient terms that assign the intellectual property they have to you. This can also be a point of contention with an independent contractor. For instance, if you have somebody writing software code for you or designing a website, they're probably going to have certain tools and materials that they want to use over and over again. If the agreement is written in such a way that it assigns everything to you, they're not going to sign on the dotted line. But also you want to be protected so that the final work product does become yours and is not theirs, so they don't have you over a barrel. There are ways that you can write the agreement that does both. If you have any more questions about how to do that, please feel free to contact me at my law firm. Thank you.